have to get this all in by the 22nd.
Okay, that's fine. May I approach? Okay.
Oh, yeah. Good.
He just filed his reputation, he just up there that. I don't think that he realized that you were.
Oh, it's fine. You better call the time back.
I don't mean Bryce, I don't mean Jim, Jim is super nice.
Oh, no, that's fine.
Yeah.
I'll take this one.
Okay, case number 198, State of Ohio v. Jennifer Phillips, President of the State's Prosecutor Collins. But on behalf of the defense, Attorney Sarah Barger. You're Jennifer Phillips?
Yes, Your Honor.
And Ms. Phillips is charged with possession of cocaine and aggravated possession of methamphetamine, both with 3 felonies. The defendant filed a motion for treatment, intervention, I should say, in lieu of conviction. The court ordered a pre-hearing report to have received. I included in that is documentation from National Recovery Services that the defendant has been enrolled in treatment since November 22nd. That's to date, 10 and 23 sessions. Did miss one due to court date, and then had a period where she had positive COVID. She used for like 4 or 5, it's about 4 sessions, but otherwise all sessions were attended. The only positive has been Norfolk, which is Suboxone. And is that Suboxone you're getting, or Victron? Suboxone, okay. And that's prescribed here in MAT, right? Okay. All right, and so the probation department indicates that your criteria that's recommended and that I have been provided Ms. Phillips with a plea of guilty and entry granting intervention in lieu of conviction. Now, I'm sure your attorney has gone over this with you, but well, before I get to that point, I have here a document that's entitled plea of guilty, and then also an entry that would grant intervention in lieu of conviction, and 4 pages total, including the entry. And on top of page 3, there's a sentence that says, "I enter this plea voluntarily," and right below that it says James Phillips 217.2, and it's a proposal to plead guilty to the 2 counts of the indictment. Now, you recall signing this document?
Yes, Your Honor.
And signed it with Ms. Barker present and plain to you?
Yes, Your Honor.
And you understood this agreement to plead guilty, which means there won't be a trial. The next step would be a decision on your request.
Yes, Your Honor.
And even though it's been a month ago, you still want to do this.
Yes, Your Honor.
Now, as I said, I'm sure that Ms. Barker explained this to you, but I have to explain it on the record to make sure that you acknowledge and understand it. Normally, when a person pleads guilty to a felony or is convicted after a trial, there is a sentence. And that can be a prison term, it can be a fine, it can be probation, control, or it can be a combination of those. And these 2 also are very possible license suspensions as well in 6 to 12 years. If that happens, once that person is sentenced, regardless of what the sentence is, then that person has a felony conviction. And that will be a record. Now, there is a program for people who have minimal records and for whom the defense was caused primarily by their drug dependence or abuse or mental health. And if that person, depending upon their criteria, in this case, if you meet the criteria, then that person can get an intervention with a conviction. What that means is that person pleads guilty, but the court accepts the plea and it is put in your file and is public record, you're not convicted, because until you are found guilty by the court and sentenced, you're not convicted, even if guilty. So, while you're in this program, if you're asked, do you have a felony conviction, you can say no felony conviction. It will be a pending felony, but not a conviction. Now, the advantage to you is this. You have the opportunity to go through this treatment plan to address the substance use disorder issues and if there's any mental health issues as well. And you are put under supervision for a period of 2 years. The law requires you to be under supervision for a minimum of 1 year. During that 1 year, you have to be alcohol and drug free, meaning no drugs other than those which you have a lawful prescription. And then you have to comply with certain conditions of supervision. Now, the supervision conditions for this program are much less strict than they are for a person who is found guilty and sentenced. So that can be from 5 years. I always make it 2 years. I think that's a long enough time for a person to show what they're going to do. And if you are successful to comply with your treatment plan, and it may well go for more than 2 years, but if you've done it for a period of 2 years, comply, and you pay your court costs, and you comply with the conditions of supervision, then the probation department will notify the court, and at that time, even though you pled guilty, the court will put on an entry that dismisses the charges against you. So even though the file shows you pled guilty, the case is dismissed. Then what happens is I set the case to be for a hearing to determine whether or not to seal the record. And unless something happens between the time it's dismissed and the time of that hearing, I'll dismiss, I'll seal the record. And then what happens is that all references to those charges are taken out of the public domain and sealed. Law enforcement records are removed from the computers, law enforcement, police records, prosecutors' records, courts' records, and they're all held in a sealed area. Now, what that means is they're not destroyed. So what that means is no one's allowed to access them except in a couple of situations. That is, well, maybe in one situation, if there's a new felony charge, then the court, the probation office, prosecutor are allowed to access those records for the purpose of determining that they had that procedure, because you don't get 2 bites of the apple. And it also has some bearing, perhaps, on the sentencing for the defense, depending on what it is. But with that exception, no one else will ever be allowed to see it. And so in the future, then the answer when asked if you have a felony record, you can say no, and it's a true statement. And so that's a big advantage to you. That's the advantage that you have. Now, the disadvantage is this is the last chance you have to defend and fight against the charges, if that's what you want to do. So you don't get to try this for a couple of years, and then it doesn't work out. You come back and say, well, I gave it a shot. Now let's have a trial. No, that's not the way it works. You can have a trial, or you can do this program, but you can't have a program. So you understand that?
Yes, sir.
Okay. Now, the agreement says on page 1 that you're going to plead guilty to counts 1 and 2. Count 1 is possession of cocaine under ORC section 2925.11, and count 2 is aggravated possession of methamphetamine under the same statutory provision of the revised code. Both of those are 5th-degree felonies, and the state should understand the maximum penalty for that could be 12 months in prison on each count. Minimum would be 6 months in prison if they're proposed. There could also be a fine of $2,500 in each count. There could be a license suspension between 6 months to 5 years in each count. And if ever convicted and sentenced to prison, because all of those things could be ordered to be served consecutively, so you could have 24 months in prison and $5,000 fine. You understand that?
Yes, sir.
You're not facing any other felony charges anywhere?
No, sir.
You're not on probation, community control, parole, or post-prison control for a felony?
No, she's not.
Not including this case, I mean any other place.
Oh, no.
Yeah. This is pre-trial supervision, so you have to. Now, I have to explain to you the worst case scenario for you. So, if you are put into the program and the probation department feels that you have not complied with any of the supervision conditions or you fail to complete the treatment plan, they have to file written notice at the court. You are required to get a copy of that. And then you will have a hearing, and at that hearing you will have counsel. And if the outcome of that hearing is that you have failed to comply, then at that time the court will terminate you from the intervention program and then find you guilty. At that point, then you would be subject to being sentenced between 6 and 24 months and fine up to $100,000. If that happens, and you're sentenced to prison, once you complete the prison term that the court orders, the law provides that the parole authority could, once you've served that prison term, decide that you should be put under post-release control supervision